Alors, bonjour à tous et bienvenue à notre Coffee Break CDN, pause café virtuel sur la planification de la succession d'entreprise. Cette série est rendue possible grâce à l'aide de nos partenaires, la Caisse populaire de Clare, la Caisse populaire acadienne, Grant Thornton, CDR Acadie, TriNav et Dow Law Inc. Financement a également été fourni par l'APACA. Je m'appelle André Leblanc et je suis le gestionnaire de l'équipe des services en affaires et en entrepreneuriat du Conseil de développement économique de la Nouvelle-Écosse. Le thème de la pause café aujourd'hui est la succession d'entreprise et les questions juridiques ou légales particulièrement qui sont associées à ce sujet-là. Avec notre expert Dave Dow, l'avocat Dave Dow de Dow Law Inc. Dave a non seulement obtenu son diplôme de droit à l'Université de Dalhousie, mais il est également titulaire de bac en administration des affaires de l'Université d'Acadia et d'une maîtrise en administration de l'Université de Moncton. Dave est également un entrepreneur accompli et c'est ce lien-là qui est également très important pour la discussion d'aujourd'hui parce qu'il a marché dans les mêmes bottes, si on peut le dire, que plusieurs entrepreneurs. Les panélistes pour la session aujourd'hui seront Jeannot Chiasson, membre de mon équipe et conseiller en affaires pour certaines régions du Cap-Breton, et Ryan Robichaud, un autre membre de notre équipe et conseiller en affaires pour la région sud-ouest de la Nouvelle-Écosse et particulièrement la municipalité d'Argyle et ses environs. N'oubliez pas que vos microphones doivent rester en mute jusqu'à ce que vous avez une question à poser après la discussion des panélistes. Et vous pouvez également demander ou poser vos questions avec la fonction de chat du webinaire. Avec ça, Jeannot, je voudrais te passer la parole pour lancer la discussion.
Merci, André. Bon matin à tout le monde. Good morning, Dave. Thank you for participating with us in this. I would like to begin by maybe, in a more general way, if you could maybe talk a bit about sole proprietorship and incorporation and the differences between, especially as it relates to a small business needs or an entrepreneur's needs, and maybe also touch a bit on what could be disadvantages of incorporation.
Okay, the very broad and very good question. As any good lawyer will do, I'll give you a couple of disclaimers before I start, though. The first step in any succession planning is to bring actually a team together. So while this is going to touch on most of the legal aspects or some of the legal aspects of succession planning, it would be very important to have involved from the very start, first of all, a CPA or your accountant for yourself or your company, because succession planning is for the most part, or a great deal of it is based on minimizing taxation, which is their bailiwick, obviously, as well as your financial planner. So it's not a one step, one shop. You really need to consult all of your professionals in respect to what you would do. And the second disclaimer, obviously, is as well, I'm not offering any legal opinion as to your personal circumstances here today. This is meant to be a broad, general approach to the questioning, and certainly anything that you were to do afterwards in respect to what you hear here, I would certainly encourage you in a strong fashion to bring your own professional team in and ask them the questions to make sure that the answers are appropriate to your personal circumstance. So in relation to the question about sole proprietorship versus incorporation, as most probably in this discussion would already realize, A sole proprietorship is the fashion in which you would run your business or what it is that you're doing to generate your revenue stream in a personal fashion. So sole proprietorship, for the most part, equals whatever you do is on you personally. And it would include any debts that you incur are in relation to your business are yours. Your tax rate would be yours at a personal level. And any liabilities or things that might go wrong in your business, again, may fall on you on a personal level. So there is a greater amount of risk involved to an individual that is in a sole proprietorship position as opposed to an incorporation. I mean, the second part, and the one that kind of goes in between those two, there's also partnerships. So you may have partners that form up that do not have incorporation on their side. Incorporation is a question that arises often. Do I incorporate? Don't I incorporate? Often the answer to that question comes back to, what is it going to do to me, first of all, financially? Will the savings from a tax perspective be offset by being incorporated, or will it just add another layer of accounting and another layer of legal services and another layer of taxation to me? So the difference between the two, in incorporation, you tend to decide to incorporate for two main reasons. The first may be a liability situation, that you want to have the liability of what it is that your company does separated from your own personal assets, so that if something were to go wrong, they're not coming after you personally for what it is that's gone wrong in the function of your business. The second, and probably more frequent starting point for people, is the taxation issue, that you would be taxed at a corporate rate as opposed to a sole proprietorship, which would be taxed at whatever your income tax level is, possibly the top personal tax rate. Again, I think the whole nuts and bolts of the taxation probably goes beyond this, but it certainly comes into the question that you're going to ask before you decide whether you're going to stay as a sole proprietorship or go as an incorporation. The incorporation actually creates a separate legal entity within the world. So while as a sole proprietorship, when you die, your sole proprietorship and everything that's involved in it is you personally, and then it's open to the probate world and everything, and we'll go on and maybe talk a little bit more about probate later. Incorporations live on forever. So it allows you in incorporation not just to shelter the assets away, it allows you to shelter the growth away from the taxation aspect of it, so that you can reinvest it without having, if you're in the top bracket, 40 or 50% being removed, the corporate tax rate is around 15%. So it allows you to retain and grow your business and treat it as a separate entity. Now, in sole proprietorships, what happens often is everything's mixed together and accounting's a disaster. Not in all, but certainly it's a possibility. In incorporation, it should bring into the picture you separating your financial affairs, so that the corporation is not you personally. It is growing and it is employing people, and you would choose to treat it much differently than a sole proprietorship. Risks associated with incorporation. I know. Obviously, I almost think of that question as a two-edged sword. It's the risks associated with being a sole proprietorship rather than being incorporated. Although there are control issues, there are Revenue Canada issues. For the most part, as operations grow in size, there's a much stronger desire and need for an incorporation to take place. Any follow-up on that, or?
No, thank you, Dave. I think that's a good point to lead to my next question. So just a heads up, I'm going to ask the question both in French and English. Answer in the language that you prefer. So my first question, which you kind of touched upon, c'est quand le meilleur temps d'incorporer? Combien de temps faut-il pour le faire et quels sont les coûts associés? So when's the best time to incorporate? How long does it take? And what are the costs associated with that?
D'accord. Okay. With respect, my abilities in French, well, they are limited, and be responding to questions like this in French, we will be more than 45 minutes to get it out. So I will probably stick to English in the responses.
No problem.
The best time to incorporate very much is a personal circumstance, taxation circumstance for the individuals, or liability circumstance for the individuals. The incorporation process itself, maybe I'll just touch on what that is in Nova Scotia. Were you to decide that you wanted to incorporate, the time required to do that isn't that long. I mean, within a week to 10 days, normally we can have an incorporation up and running. The process, though, that I advise all of my clients, and I'd advise anyone else to go through, if you are anticipating incorporation or would like to be incorporated, you think, the first step would be to talk to your chartered accountant or your professional accountant for the tax ramifications of doing that. And also to talk to your lawyer about the possible liability issues associated with that. But once you've reached that point that your tax expert has told you, no, this from a tax perspective, earning perspective, and liability perspective is your best move to incorporate a company, how I normally start the process is by asking the accountant to give me a letter of instruction as to what this corporation should look like. So the formation of a corporation includes an articles of association and a memorandum of association for the company, which are the founding documents for a corporation. And the very first step is to pick the name. If you're in a hurry, names that are often used now are numbered companies, so we don't go through this search. There's a search of the database it's called a nuance search. And it's to look at and say, is that name acceptable to the province of Nova Scotia if you're doing a provincial registration? And what they try to do is eliminate companies that would be too much alike, would infringe on a name that's already out there. So as you can imagine, in the municipality of Clare or in probably any of the smaller communities in the province of Nova Scotia, there are going to be certain names that once you stick them in a company become very difficult to get because everybody has the same last name. So often we'll have what are called conflicts in respect to that, and they tell us to come back for a second name. So in the process, as it starts, we would take 3 names from the individual and say, okay, we'll run a nuance search on those, and nuance search on those, and we'll get an answer which one's acceptable. After that's done, usually with the letter of instruction from the accountant, I would then become the initial shareholder of that company and form the company. So the memorandum of association of a company is the part of the document that lays out what the share structure is going to be, who are the shareholders, how their holdings can be, and the different types of shares and how they're going to work. The articles of association, most normally, if you go on the registry of joint stocks, there's standard articles that are used which lay out the powers of the corporation. So this company is going to be able to do certain things. And historically, they would have been a very limiting document. Now the one that's used, the standard is they can do just about anything except for form a bank, and even then, I suppose if you needed to, they could be amended appropriately. That's a 22-page document that just gets used as a blanket for the most part. At that time, I would form that company by issuing the number of shares that are asked for from the accountant. Normally, it's 100,000 shares, and they want you to authorize that, and then you can amend those afterwards to get them to be either preferred shares, common shares, whatever the case may be. And we'll talk about shares maybe a little later on in a little more depth. So once to start it, I just take one share, which is a common share, and create the company. And the reason I do that is because then whoever it is being incorporated or having the incorporation done, I don't have them in signing 48,000 documents, merely sign all the documents, get it all done. And my last act as the shareholder director of that company is to resign from all of my positions, appoint the new shareholder and issue them the correct number of shares and variety of shares that are in the letter of instruction, and resign. So that's kind of a nutshell of the formation of a company. And the cost associated with that, obviously, if it's you're coming in to do your lemonade stand or whatever, a standalone, it's under $2,000 start to finish, and that includes the purchase of the it includes the legal fees, but it also would include purchasing your corporate seal, the purchase of a book, one of the black attaché cases, and all of those things that are need to be done. And further, at that time, what happens, Revenue Canada then issues a business number, which is kind of like your social insurance number, only for the corporation. And from that, again, with your tax professionals or whoever it is you're dealing with from accounting perspective, they would then go forward and open HST accounts possibly for you using that same number, or they would open payroll accounts, CPP, UIC, EI, all of those kind of things. So that's a kind of a nutshell of the incorporation process. Now, again, big question in incorporate, don't incorporate. Sole proprietorship, everything is line 150 income that you earn. In relation to corporation, you now can choose how you want to pay yourself. And you may decide that you want to pay yourself through earned income, line 150, which allows you to have CPP deducted, EI deducted, all of those things, and allows you to build that. The credit aspect of it, that of course in small business, you're going to pay twice as much to get CPP as a sole proprietor is going to pay if they do their payroll the same way, because you will be responsible for the corporation's half and the half that would be for the person. So again, questions to go over with from an accounting perspective and a taxation perspective. Tax rates are different on dividend income than they are from earned income. And the benefits that you would reap from those in the future can vary greatly. There are people that look at it and say, I never want to pay CPP because I have to pay twice as much. I'd sooner invest the money. I can get a better rate of return than the government of Canada in doing it myself. Obviously, the risks associated with that are maybe you're not as good an investor as Revenue Canada. So as to best time, it's very much a question that has to be dealt with on a personal basis by you with your professional advisors.
Thank you, Dave.
Excuse me, Dave.
Yes.
I have a question. You spoke to the registration. I deal with a lot of clients and I always print off their joint stock document. And often I see the lawyers as the recognized agent and the registered office being lawyers' offices. Is this normal or is this common?
It's common. I'm probably the recognized agents for 60 plus companies right now in the province of Nova Scotia. When you have an ongoing relationship with a recognized agent, and there's reasons to do it. If it's maybe a continued over company, then they have to have a recognized agent in the province of Nova Scotia. If they aren't in the province themselves, obviously lawyers are frequently reached out to. Recognized agent's job as well includes the acceptance of any service in relation to the corporation if there's any lawsuits or anything like that. So again, lawyer's office is a normal place. For a lot of small businesses, the reason to go with a recognized agent that's a lawyer is that we will do and can perform the function of doing the annual minutes for the annual meeting. In small corporations, there's a tendency to have individuals that are running their own show. They're doing everything. They don't have a lot of time to waste on paperwork. Doing their annual renewal is one of those things that gets maybe left to the sideline if they don't have somebody tasked with looking at that, and they then can be revoked and all kinds of things, which are just a pain in the butt. The actual expense of having a recognized agent at this point for a year is under $200 in legal fees, and they look after actually renewing and preparing your annual meetings, which would include things like, yes, we're going to forego certain parts of the income tax reporting or whatever. There's all kinds of things that can be in those meetings, minutes that are required from tax perspective that we just incorporate. So not uncommon to have recognized agent as a lawyer. Again, though, you can have them as the bookkeeper. You can have, as long as they're resident in the province of Nova Scotia, there's no requirement that they be a lawyer.
Thank you.
You're welcome.
Alors, à mon tour, moi aussi, je vais poser la question à M. Dow en français pour le bénéfice des auditeurs et téléspectateurs. Et ça revient à ma première question et le sujet d'homologation, un terme qu'on n'entend pas très souvent. Alors, j'aimerais, M. Dow, que nous explique un peu c'est quoi l'homologation, ou en anglais probate, et ses effets sur la planification de la succession. In English, as you touched earlier in my first question, the question of probate and the considerations given in succession planning.
Okay, so and that's a great area to go into. It succession planning, obviously, we didn't really define what that is, but it's going to be the change in control or passing on of your assets to someone else. It may well be within family, it may well be outside of family, but you need a plan, especially in relation to your business, as to how it's going to keep on going, because while you are going to die and reach the probate stage, your corporation may not. So we'll look at probate to start off with and talk a little bit about that in relation to succession planning. What probate is, and there is what is called the probate court in the province of Nova Scotia. It's one of the divisions of the Supreme Court of Nova Scotia. It is by nature a court of inactivity, I'll say, in one respect, and I offer that partway in jest. They're a court that is reactionary, and they're a court that can be mostly just paper in nature. So while you will go to probate court with someone when they pass with their affairs, but it isn't really going to be in a courtroom for the most part. It's going to be filing paperwork, doing things, and it's with a lawyer for the most part. So while we'll submit to the court, they'll respond in writing. So it's not you're in fighting over something. But probate is, in a nutshell, it's the collection of taxation by the government of Nova Scotia when someone dies. So and there are two ways that you can die in Nova Scotia. You can die with a will, or you can die without a will. So both of them bring in probate, possibly, depending on your circumstances. And probate is the collection of the taxes, or inheritance tax, you'll hear it called, although in the province of Nova Scotia, they're called probate fees because they don't treat it as taxation. But in the end, you're giving money to the government so you can figure out the difference between taxation and fees. Probate fees in the province of Nova Scotia are $1,002.65 on the first $100,000 of an estate, and $16.95 per thousand thereafter, up to whatever, the sky's the limit, as rich as you are. So when you look at it, overall in most estates, in fact in all estates, it's under 2% of the value of the estate. So yes, if you're worth a fair amount of money, it's significant. But in a lot of cases, no, it may not be significant in the grand scheme of things, because whoever's getting whatever's being left behind, it's almost a windfall. So if they have to pay a little bit, that's fine. But they're still planning to get around probate, and people do it all the time, and lawyers work around that all the time, and it's a big part of the succession planning thing. Now, to look at the probate process, what happens when someone dies, they will, if it's in a will, they will name an executor. If there is no will, then there is the Intestate Succession Act, which says who can apply to be the administrator in that case, as opposed to executor. For this, I'm going to call them both the personal representative of the estate. So the personal representative of the estate is the person that looks at winding up the affairs of the individual that has died, and at law, they become that individual. So most often, most frequently, you'll see husband and wife kind of things. So you'll see children. The bigger the estate, you may see a CA or CPA. And also lawyers will serve as well, depending on, you know, the intricacy and what's involved in the estate and the costs that are going to be associated with it. For the average individual, when you look at it, if you're not incorporated, if you're not a company, most people can, between husband and wife or significant other, spouses, partners, whatever you want to call them today, in whatever circumstance, whether it's a registered domestic partnership or a legal marriage. And the only reason I bring that up, common law relationships, if there is no will, the common law spouse is not recognized in the probate process. So something from your succession planning for sure is, if you are in a common law relationship, you should make sure that there is a document in place that does specify what that person is supposed to get. In avoidance of probate, which is what I'm taking this question to be about, between partners, you can have only the part of property that is passing through the will or through the intestacy goes through probate. So part of your estate or part of what you're worth may pass through probate, other parts may not. For instance, in your matrimonial home or your house where you live, your primary residence, or any other property, real property as opposed to personal property, real property being land, buildings, that kind of thing. All of that can be held in Nova Scotia in two different ways. You can hold it jointly with someone else, or you can hold it in fee simple alone. For the most part, in partnerships and so on, and I'm speaking personal relationship partnerships here, you will see it held as joint tenants. And what joint tenancy is the establishment that whatever is held jointly passes to the partner or the other person on the deed or whatever through survivorship under the Survivorship Act. So if you put your partner's name on it as joint tenants, that will not go to probate. In the case of your primary residence, that could be worth $250, $350, $550, whatever $1,000, by passing by survivorship, obviously that eliminates the taxation on that and saves your partner 2% or 1.7 whatever percent of the value at the time that you of your demise, and it goes both ways. So perfect way to succession plan in relation to your primary residence or any of your lands. Now, again, there's reasons sometimes you don't want to do that. There may be second relationships where you wanted to go on to children from a primary relationship and all. Again, the concept is you can get joint ownership. The specifics for yourself would be talk to your own representatives. As well, joint bank accounts. There is the ability to have more than one name in a bank account. I would say if you're setting it up for survivorship, that you should make sure that that's known at the bank, because in 2008, and I think it was a case, it was maybe Pecor, I think the Pecor in the Supreme Court of Canada, they said, we're no longer going to say that joint ownership of an account automatically passes to the other individual, because often there's a name added to the account, it's one of the children, and they're looking after a senior or an elder or someone else, and they're using only their money, and it isn't the intention that it pass all to them. There may be 5 children and it should be split 5 ways. So the court said now joint accounts don't necessarily pass right away, but certainly if you've laid out in your will and your planning and you've stipulated it to your bank that it's for survivorship, that will eliminate it from probate and the fees associated with it. Share structures become more difficult, more problematic. You can succession plan for shares to pass, but you're going to go into a trust situation, and that's far beyond what this seminar is going to deal with. So I would say if you get to that point that you want to completely evade, or not evade, but completely eliminate probate from the equation, again, financial planner and a lawyer that does trust and succession planning and so on would be the stop. But certainly in a normal situation, the sole proprietorship, joint ownership of everything by the two partners, the spouses, or whatever you want to call them, can allow for pass of the first person to die, and everything passes to the other by way of survivorship, and there is no probate, no lawyer with his hand in your pocket. It just, everything goes, and it's neat and clean for the first. For the second, it's a little more involved. There is, and you can still do this kind of thing and go down generations and so on. I caution my clients not to add other names such as children and so on to their properties that they aren't prepared to deal with what the fallout of doing that is, because there are risks associated with that. Bankruptcies, divorces, you've actually, despite you may be able to make a statutory declaration upon transferring the asset that says that this is not transferring a beneficial ownership. It's merely a tax planning strategy which can protect you, but you still can end up in things that are not in your best interest. So that, again, to go to the next generation, much deeper conversation. And again, I would say you should be talking to your financial planner, accountant / lawyer. In relation to probate as well, the executor would take over and will allow for the change of the ownership of the shares for the person that has died. Most frequently in succession planning, this is bringing in a whole other area of it, would be if you have partners or other shareholders, and I don't want to confuse the two terms, because partnership is not an incorporation. Again, it's two sole proprietors that are working things out together. But there's normally there's a partnership agreement. In the case of corporation, there's shareholders agreements. So in closely held corporations, as opposed to, Coca-Cola is a corporation, multinational, all of the things go along, whole different conversation. What I'm aiming this at is, the mom and pop operations, seafood plants, all kinds of small corporations, we'll call them medium to small corporations. So in relation to it, when forming a corporation, from a succession planning perspective, a very important document that you should add to your toolbox that you're going to be using would be a shareholders agreement. And I picture that, if you were looking at it from a family law perspective, a divorce perspective, it's planning your divorce before you get married. And it would allow for what is going to be the succession for this corporation. How am I going to leave this corporation? What am I going to do with the shares to the corporation? Who can I sell them to? Who can I not sell them to? Who can I leave them to? Rights of first refusal. That document's so deep we could spend the next 2 months talking about it and things that can go into them. I'm going to leave it at, if you're going to incorporate, your best plan of action is to create a shareholders agreement in advance, and it covers not just the end of the corporation, it also covers the running of the corporation. Who is going to be on the board of directors? How are they elected? Just a myriad of questions in relation to companies. Back to the probate aspect of this, obviously shares going to probate cause some real legal issues, and you should be planning for that in advance.
So Dave,
Well,
oh, sorry, Brennan.
no, what's it, Ryan?
So my last question, we talked a bit about kids being involved. so this kind of ties into that. So what's the best way to pass your business down to the next generation? C'est quoi la meilleure façon de transférer votre entreprise à la prochaine génération? Either sole proprietorship or incorporation.
Well, the sole proprietorship, you may bring your child on and make them bring them in as a partner. And again, I'm going to caution the response to this. It's not a best worst scenario. It's a you scenario. So there is no right or wrong answer to what it is that you're going to do. What you're looking at in succession planning is you want the entity, whatever it's going to be, to carry on and do the same kind of work or be able to expand into other areas. That may be as simple as bringing your child on, hiring them, and the day you die, they've taken over all your customers and away you go. More likely, you're going to be in this day and age, as you grow your entity, whatever it is, that there's going to be a desire for incorporation. So you can bring on the incorporation. You can start to sell shares. You can start to transfer shares. You have to be careful in the movement of shares because Revenue Canada is in the mix in absolutely every one of those scenarios. So you may choose to having, and this comes to the question of shares, common shares versus preferred shares, the difference between these two types of shares. When you form a company and you come up and the accountant gives you the type of shares, they will give to the lawyer what the attributes of those shares are going to be. So are they voting shares? Are they non-voting shares? Are they a common share, which controlling share? Are they a preferred share, which tends to be used more for disbursement of dividends to pay people? And this, again, very simplified in what this share structure, you can run an MBA on it. But so you may choose to bring your child in from a succession planning perspective, or anyone else. You may do it through hiring them as an employee and then starting to transfer shares to them. You may sell them to them. In sole proprietorship, you may have, depending on how you're running your enterprise, maybe your retirement's based on the assets that you've bought to do the job. So in a case like that, you might need to sell to your child as opposed to give to them, and you do what's called an asset sale. And it's as simple as, okay, I'm going to sell the assets of the company to you, or I'm going to maybe even gift the assets of the company to you. So it can be that simple that you set up an asset purchase agreement. And again, all of these things are aimed at Revenue Canada, minimize taxation, don't get offside. In the incorporation, you may structure it that you sell out controlling shares to them eventually. You may actually finance the operation for them and keep some shares, get rid of the controlling and voting shares and keep preferred shares where there's an agreement put in place that you're going to be paid out over the next 10 years or 20 years or your lifetime, so much a year through a dividend on those shares. So the plan can be anything. They're multiple. The biggest thing for this is to make sure you make a plan. The succession plan should really start from the day you incorporate or the day you start your business.
Alors, merci Dave, merci Ryan, merci Jeannot. On devrait maintenant passer peut-être aux participants s'il y a des questions additionnelles avant de poursuivre à des questions supplémentaires que les panélistes ont. Alors, je vais juste vous offrir cette opportunité-là aux participants s'il y a des questions additionnelles. So, thank you, Dave. And at this time, we'd like to allow the participants, if there are any questions from the floor before we pursue other questions from the panelists. En attendant rien, on passera peut-être à une dernière question des panélistes pour terminer la session. Alors, we're going to go to one last question from the panelists to wrap up our session.
Oui, Dave, premièrement, merci pour tes bons conseils et toutes tes connaissances. C'est fortement apprécié. Une dernière chose, peut-être un peu d'élaboration sur les instruments que tu as mentionnés. The idea of those instruments like trust, power of attorneys, wills, the appointment of executors. I'm thinking specifically, I've got a few friends that are into the fishing and with very lucrative type assets and licenses. And the problem is always being, how do I transfer that to my children? You know, and all the liabilities that seem to, so you might want to expound on that a bit.
Sure. And I think one of the most important things you've touched on there in the question to start off with, it is a myriad of documents that are involved in this for your succession plan. And you should start with a will. Everyone needs a will. If you set it up correctly between spouses, maybe that doesn't end up being functional, but then again, you must know which one of you is going to die first to know which one to do. So you do two wills. And powers of attorney, wills are for what I sometimes jokingly say, wills are for dead people. Power of attorney is for somebody that wishes they were dead. Well, you have to have the power of attorney, and I would suggest at an early age, because there's two different kinds of powers of attorney. There's the blanket old ones, which were used in companies where partners would have one deal with one part of the company and the other. The newer ones and the ones I'm doing more frequently are enduring powers of attorney. And you have to plan your succession not just for if you die, but if you become incapacitated. So you would name a power of attorney. You would name, in both cases, an executor for your will. You would find someone that you trust completely. You would find someone that's capable in the area that you're going to give them or designate the power. Because power of attorney is very much a responsibility, not a power. They have to work as you would in your best interests. So your power of attorney and will are not particularly expensive documents to start off with. And I'd say anybody that's going to do succession planning, get in and do those right away. As far as trusts go, in the formation of your company, at the same time, you would talk to your financial person or your CPA and talk to them about trusts and how they may be useful to you. There are family trusts and there's all kinds of information. Again, a whole course can be taught or two on that. The only thought is in your succession plan, talk to them in advance to see if it isn't something that is of use to you and your personal circumstance. And the thought behind trust is an ability to possibly income split as well as maintain control over things in the future. In relation to other documents, we've touched on a few of them, but I would say the very basic that you want to get to minimize taxation is to get in for a will, get in for a power of attorney, and talk to your CPAs, look at whether an incorporation is the way to go, and then at the end of the day, bring the legal services into it for what is required and to set up your plan as a complete unit using your entire team.
Merci de nouveau, Dave. Et il y a une question de la foule que j'ai reçue par chat, mais je vais laisser l'individu poser la question. Alors, Alain a une question à poser. Alain?
Yes, thank you, Dave, again. You mentioned gifting shares. Is it possible for someone who has a company which has assets to gift shares to their children to transfer over the company basically without having an assessment done of the fair market value of those shares? Like, can you give them for free, I guess?
I would say in respect to anything in that order that you would talk to your CPA for the tax ramifications, because that's what it is at the end of the day. And Revenue Canada is a beautiful organization, but in the end, they're the one organization that sets the rules, and they're right until you prove them wrong. I offer no opinion as to if you can successfully pass it without any ramifications from a tax perspective, I'd leave that to the tax planners. The one other thing, though, in respect to the sale of a business or the passing on, that I would like to mention before I go, is that if you are in a position that you're looking to get rid of your business, you're looking to sell your business, there's professionals that handle that. But as well, you would always look and think, are you doing an asset sale or transference, or are you doing a share sale? And there's a vast difference between the two. An asset sale is you're actually selling the assets out of the company, and you may keep the company and transform it into a holding company. The share sale allows you to actually sell the whole entity, and it goes to the new owners, but continues on, different shareholders. The major difference, and in succession planning, you really want to look at that and talk to your tax advisors about it, is that you can trigger capital gains rather than regular income. Different style of income can significantly lower your tax rate. So buying the shares is often not wanted by the company, by the person that's going to take over, because of the capital gains and the depreciation of the assets. So whenever you're looking at anything in succession planning, look at how you're going to wind up, get rid of, or sell the asset, and always have a tax expert involved.
Avec ça, merci l'avocat Dave Dow pour sa participation et ses conseils partagés sur le sujet juridique ou légal de la planification de succession d'entreprise, de transfert ou de vente. Et de nouveau, merci à nos partenaires pour avoir rendu cette session possible.